All right. Welcome, everybody. I am Lynn Harmon Walker, and I'm very happy to direct the GW Law Environmental and Energy Law program. And I am especially delighted to welcome you to this talk on the very unusual case of McGirt versus Oklahoma. I want to welcome our expert speakers and thank them for the time that they're taking out of their busy academic schedules to talk with us today. Professor Elizabeth Cronk-Warner is the Dean of the S.J. Quinney College of Law at the University of Utah. And before her deanship, she was a tribal judge. She's an enrolled member of the Sioux tribe. Am I saying that correctly? Yeah, it's as in Sault Ste. Marie, right? Sioux tribe of Chippewa Indians. And I highly recommend to you her fascinating and creative articles and other writings on Native American and environmental law. Professor Robert J. Miller of the Sandra Day O'Connor College of Law at Arizona State University is a current tribal judge, and he's an enrolled member of the Eastern Shawnee tribe of Oklahoma, which means that the ruling on this case directly affects his tribe and, of course, his scholarship that he'll share with you today. So let's get started. We hope to have a little time at the end today for a brief Q&A session. So we'll start with you, Professor Miller. You kindly agreed to provide a background on this case.
Okay, folks, July the 9th, I woke up in Portland, Oregon, and the Supreme Court had issued what I call the bombshell of McGirt v. Oklahoma. I've given many talks on this, written several articles, have a law review article out right now on this subject. This is of enormous significance, and Dean Cronk's going to talk about, then focus on the environmental implications of this. But I'm going to try to give you a 1-hour talk in 25 minutes and talk as fast as I can, I guess. But I was surprised that that the Muskogee Creek Nation won this case, and the impact it's having in Oklahoma. And what Lynn just mentioned is my tribe in Oklahoma, its 1888 reservation, no doubt is still in existence after McGirt. Yesterday, folks, an Oklahoma state court decided that the Ottawa tribe's reservation still exists. The Ottawa purchased their lands from us and moved into what was our 30,000 acre reservation. So this case is of significance to many tribes in Oklahoma. It's been cited by courts already, of course, across the country. The Oneida tribe in Wisconsin won their 7th Circuit appeal about their reservation based on McGirt. So I'm going to talk to you, like I say, fast. What can we do? I want to start with this. What has always been American policy towards Indian nations and Indian peoples? It was to take the lands and the assets as fast and as cheaply as possible. This is an enormously significant letter that George Washington, General Washington, wrote to the Congress at the end of the Revolutionary War. After we signed our treaty with England, Congress was thinking, what should it do to the Indian nations? And here's what George Washington's advice was. Don't war with them, buy their lands. They will disappear. They are weaker than we are. They are not civilized. They're savages. And I want you to read this last part of the letter. He analogizes Indians to animals. I guess I should say he does more than analogize, because look at that underlined part. This is known as the savage is the wolf letter, because this is the advice Washington was giving the Congress. Don't fight the tribes, just buy their lands. They will disappear just like the animals do. So this has a little bit of environmental implication today, I guess, this provision. But look what he said. Animals and Indians are both beasts of prey. This is a pretty chilling letter when you read this, folks, and when you think it was really federal Indian policy into about the 1960s or 1970s. So I want you to think of this in the background as we talk about the Muskogee Creek people and the other tribes that were moved to Oklahoma when it was called the Indian Territory. It was not a state. My tribe was in South Central Ohio in 1832, and we were removed. We had our own Trail of Tears to where we are today in the very northeast corner of Oklahoma. So George Washington's policy is epitomized by what's called the allotment era of federal Indian policy, folks. It's called allotment because the reservations were broken up into little bitty pieces. They were given to individual tribal citizens. And of course, most native peoples then either sold, were defrauded, or lost their lands to tax foreclosures. President Teddy Roosevelt in 1906 said this act was the great pulverizing engine designed to destroy tribal nations. George Washington, don't forget what he wrote in 1783. Tribes lost 90 million acres of land during this allotment era, and the lands they ended up with, are you shocked? Were desert lands, arid, unlivable lands. This same kind of thing went on in Oklahoma too. My tribe was allotted in 1888, the very next year after this act was enacted. Here's what I think George Washington foretold it, is what the United States did for nearly 200 years. What's relevant in the Constitution, folks? We're talking about treaties. The Muskogee Creek Treaty, my own tribe. My tribe signed 11 treaties with the United States. Muskogee Creek, probably more. Article 6, the treaty clause, they are the supreme law of the land, predominant. But you may already know this from con law. Congress can unilaterally abrogate United States treaties with foreign countries, these exclusion cases. And the Supreme Court in 1903 didn't say this blatantly, but yes, Congress can abrogate Indian treaties also. So this is the case that we're faced with for Muskogee Creek and my own tribe. Were our reservations that were created in the 1830s, the 1860s, were those treaty rights abrogated or erased? And that's exactly what McGirt is about. So what are treaties? Are they just fun old things we ignore from the past? The United States signed lots of treaties with Indian nations. Here in a Supreme Court case about fishing treaty rights out of the Pacific Northwest, the Supreme Court said that treaties are like contracts between nations. And so often in treaty interpretation, the US Supreme Court uses treaty canons of constructions, contract canons of constructions that you would be familiar with. And also what the Supreme Court has said something interesting. Treaties are reserved rights. The United States and the tribes negotiated to buy land, to buy assets, to keep the peace, to engage in trade. But those rights the tribes kept. The Supreme Court has long used this phrase, these are reserved rights. The United States did not give the tribes these rights. The tribes already possessed them. They only sold to sell X, Y, and Z rights to the United States. So obviously they retained rights A, B, and C. So this is as much, in the time I have, this is as much as background I'm going to give you on treaty law. So this takes us to the Muskogee Creek peoples who lived in Georgia and Alabama, what is now Georgia and Alabama. They, of course, were there thousands of years before Europeans and Americans showed up. Then the pressure to move, George Washington Savage's Wolf Letter, move, 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 removal. That's one of the federal Indian policies too, to get the tribes to move away. Thomas Jefferson was writing privately about this when he was president in 1803. We must move all the tribes from east of the Mississippi to the west. So this was federal policy. The Creek Nation resisted, fought some wars even, finally agreed to move west. But they were so suspicious of the United States, folks. Look what they did. You may know how tribal lands are owned. We usually call them trust lands. The United States is the legal owner. The tribe is the beneficial owner. A few tribes own what are called their reservations in restricted fee status. Well, this is what the Muskogee Creek demanded. We will not remove unless you guarantee us our new lands in the West in this highest of Anglo-American property ownership rights. And this is exactly how the lands were titled and passed to the Muskogee Creek when they moved to the Indian Territory. Look at the promises in this treaty. It will be your permanent home, solemnly guaranteed. You will govern it. Look at this other provision, folks. The Southern tribes, what they're called the 5 civilized tribes from the southeast of the US, they knew the danger of being placed under federal territorial law or state law if a state was formed around them. And all 5 of those demanded in their reservations that phrase, we will never, the United States promises we will never be under state or territorial law again. So the Creek signed more treaties with the United States repeatedly. Their lands, over 7 million acres of land in the Indian Territory, were defined in 1833. You can read the provision of their 1856 treaty. What's interesting though, folks, is just like my own tribe in the Civil War, most of the tribes in the Indian Territory signed treaties with the Confederacy. They were almost forced to because the Union troops withdrew from what's now Oklahoma. The federal Indian agents withdrew. And so the tribes were left to the mercy of the Southern troops that were there. My own tribe, 1861, as the Cherokee, Creek, etc., signed treaties with the South. After the war, the United States extracted its revenge. At this 1866 treaty conference in Fort Smith, Arkansas, the United States punished us. And I tell you, I reference George Washington again. The big tribes, and this is the Creek Nation, were forced to sell half of their reservations, 30 cents an acre. The Creeks lost 3.25 million acres of land. But notice the word I've underlined. This is the first treaty for the Creek, with the Creek, that used the word reservation. That word is absolutely a term of art today. And we're going to talk about, does that reservation still exist? This is the issue of the McGirt case, folks. Did Congress ever take away? Did it extinguish? Disestablish is the word the case is used. Did it completely erase the Muskogee Creek Nation reservation? Does it still exist today? Here's a very simple map. Look at those what are called the 5 civilized tribes. My goodness, their reservations are almost a half of Oklahoma. Now, I want to point out this map because it's got the most important tribe in the United States is listed there at the very top. I see some smiles. That's my tribe, of course. Look at the little piece of land we had up there, but notice that arrow of the Ottawa tribe. That's who won their case yesterday under McGirt, that their reservation still exists. As I said earlier, they purchased their part of their reservation through the United States from my tribe. Does my tribe's 14,000 acre reservation still exist too? I'm certain of it. That has not been litigated yet. Okay, what's the binding precedent that the Supreme Court had to apply? There have been 9 what are called diminishment cases. That's when a reservation gets smaller, or disestablishment cases where a reservation is taken away completely by Congress. This case I've been teaching for 20 some years now set out what all of us thought was a 3-part test to determine when a reservation has been diminished or completely disestablished. The court said, obviously, we look at Congress's intent, clear intent. What is the language, the specific statutory language at issue? Did Congress mean to take that reservation away, disestablishment, or to make it smaller, diminishment? Now, let me just tell you all, folks, that when Congress does that, it must pay due compensation under the 5th Amendment. So these are takings claims when the United States abrogates a past treaty and makes a reservation smaller, or certainly when it disestablishes it completely. Now, the court in Solem also looked at 2 other forms of evidence to determine what Congress's intent was. Contemporaneous events. Did Congress itself, did the tribal leaders themselves, did the public, American public, understand the reservation would get smaller or perhaps go away completely? The 3rd step I always scream about when I teach Indian law, the court even said we can look at the past 100 years of history since Congress passed that act. What happened to that reservation? Who lives there now? Well, folks, Indian peoples are 1% of the United States. So what I scream about in my class is, how can you dare use demographic evidence as attempted proof of what Congress meant 100 years ago in this particular language at issue? Now, folks, before I move on one step, Gorsuch, Thomas, Alito, Roberts, aren't they all originalists and textualists? Can you picture, what do you think Justice Gorsuch, and I haven't said this yet, Gorsuch wrote McGirt. He's the one conservative justice that joined the 4 liberal justices to create a 5-4 majority in the McGirt case. Justice Ginsburg has now passed. We have a new justice who we don't know what she knows about Indian law, and we have no idea what her position will be. But anyway, what do you think an originalist thinks of this 3-step test right here? So let's finally get to McGirt. Oh, let's say this final point. Allotting a reservation has nothing to do with diminishing or disestablishing it. Supreme Court has said that 3, 4, or 5 times. So my own tribe's reservation that was allotted in 1888, that did not automatically change the borders of my tribe's reservation. It is probably still in existence. So what does McGirt say? Well, I want to show you why I knew we had won. This is how Justice Gorsuch starts his opinion. On the far end of the Trail of Tears was a promise. I said, we've won. We've won. Then I had to read the 30-page opinion. But Justice Gorsuch and the majority looked at step 1, allotment, and the dissent, Oklahoma and the dissent said that the Allotment Act and many other acts will demonstrate Congress's specific intent to diminish the reservation. But that's not what the majority said. They read this language very carefully. They looked at the statutes that they were cited by Oklahoma in this argument. Congress never said anything about shrinking or completely disestablishing the reservation. In fact, the exact opposite is the truth, folks. I don't think I have this on the slide, but starting in about 1893, Congress tried to get the Creek Nation to sell its lands. They absolutely, totally refused. And those commissioners Congress had created went back to Congress and said, they will not sell an acre of land. So Congress goes, oh, well, okay, let's just allot the reservation. So the facts show that Congress did not even intend to change the borders. They just intended to apply the allotment policy to the Creek peoples. So the reservation still is in existence, folks. Oklahoma woke up July the 9th and found out that 3.25 million acres of land within Oklahoma are now are still Indian country. 1 million Oklahomans woke up July the 9th and found out they live on a reservation, including 400,000 people in the city of Tulsa. Complications will ensue, and Dean Cronk will be talking about some of those. Now, the court tried to hold its opinion, like it always does, to the specific legal issue in front of it. Oklahoma's criminal jurisdiction over an Indian defendant who had committed a crime in Indian country. And if you don't know anything about Indian law, state governments rarely have criminal jurisdiction in Indian country. And except for an act we're not going to have time to talk about, states do not have criminal jurisdiction over Indians who commit a crime in Indian country. So that's all the court had to say to answer the issue in the McGirt case. McGirt was a heinous criminal, sentenced to 1,000 years in Oklahoma State Court. He since was released. The federal government and the tribe criminally prosecuted him. He never got out of prison. So what did the court do with step 2 and 3 of Solem? Because you can see my very first point there. Gorsuch and the majority just read the language. What'd they do with step 2 and 3? Because this is what Oklahoma argued. This is what the dissent argues vigorously. I believe the dissenting opinion is even longer than the majority opinion. I'll let you read what Girsuch and the majority said. And this is what I and other law professors and commentators also found out on July the 9th. Solem is not a three-part test anymore that we must apply in every circumstance. So as a true originalist says, if Congress's intent is clear, we don't need to go to ancillary evidence, legal history, perhaps, legislative history. There's no need to consult extra textual sources. So I find the opinion interesting because it's the one textualist, Girsuch, with the four liberal the four liberal members of the court saying we don't need all three steps of Solem. There's no question that Congress never diminished the tribe's reservation. So I think I just have two more slides just to give you a little bit of language. I assume none of you know the history of Oklahoma, the rampant fraud that went on in Oklahoma, the involvement of federal and state officials, state judges, and lawyers, probably being bribed, appointing fraudulent guardianships to then take over control of Indian allotted pieces of land and sell them. I literally have a quotation from the most famous Indian historian, Francis Paul Pruka. He quotes a phrase that if an Indian had oil on their allotted piece of land, they were deemed to be incompetent. So the fraud that went on, folks, is what Justice Girsuch is referring to here. He said, oh, Oklahoma wants us just to go, and the dissent, want us to assume what happened in these past 100 years did diminish and disestablish the Creek Reservation. But he says this cannot be allowed. None of these moves would be permitted in any area of the law, and that would be the rule of the strong and not the rule of law. So obviously, as a professor of Indian law and an advocate of tribal rights, et cetera, I think, I love this opinion. As my wife says, it's been all McGirt all the time since July the 9th. I literally have a book contract to write, I'm co-writing a book on McGirt. Now let's see, I think I've used my time, so I do write about the question, I didn't know how Justice Ginsburg would vote. Liberal justice, of course, but she's written several opinions that tribes lost and were unhappy with. And here's the case I was focusing on. In 2005, she emphasized the settled expectations of the state of New York, some counties in New York, and some cities in New York, and that the Oneida Indian Nation could not just revive its reservation. And so that would give one pause what she thought about the 100 and some years in Oklahoma. Okay, I'm going to end because I think I'm done. All the other four big tribes, their reservations have now been recognized by Oklahoma state courts as still in existence. And like I say, yesterday, the Ottawa tribe. I think that's it. Thank you very much. And I'm looking forward to Dean Cronk's comments.
Wonderful. Thank you so much, Bob. So Elizabeth, are you ready to go?
Yes, thank you so much. Yes, Bob, thank you so much for that excellent introduction. And for those of you who are interested in learning more about that sad history that Professor Miller mentioned in Oklahoma, I believe actually Martin Scorsese is making that into a movie right now as we speak. I think the movie started before COVID. I don't know if it's if COVID impacted it, but keep an eye out for that if you're just kind of interested in learning more about that really sad history. That movie should be coming out. So my name is Elizabeth Cronk Warner, and I have the privilege and honor of being Dean at the S.J. Quinney College of Law at the University of Utah, as was mentioned before. My pronouns are she and hers, and I'm coming to you today from the Salt Lake City Valley, which was traditionally indigenous homeland. So I like to start off by acknowledging that this land, which I'm on today, is named for the Ute tribe and is the traditional and ancestral homeland of the Shoshone, Paiute, Girsuch, and Ute tribes. The University of Utah recognizes and respects the enduring relationship that exists between many indigenous peoples and their traditional homelands. We respect the sovereign relationship between tribes, states, and the federal government, and we affirm the University of Utah's commitment to a partnership with Native nations and urban Indian communities through research, education, and community outreach activities. So it seems really appropriate that we should be here today as part of this community outreach activity, and having this opportunity to talk about the case McGirt, which I 100% agree with Professor Miller really is a bombshell, and was just such a pleasant surprise. I agree with him too. I have to say I was on kind of pins and needles and was very nervous about what the court was going to do in that case, and was just pleasantly surprised when we got that decision for all the reasons that he's already articulated. So it's definitely a big sea change in Indian country. My presentation, I'm going to focus on the environmental impacts of the court's decision. And I do want to acknowledge that my presentation today is based on an article that I co-authored with Heather Tanina, who's a research faculty member here at the S.J. Quinney College of Law. And that article is called Indian Country Post-McGirt, Implications for Traditional Energy Development and Beyond, which should be coming out in the Harvard Environmental Law Review by June, supposedly. Although if you've worked with law reviews, you know sometimes things are not on their publication schedule. So I do want to acknowledge that this is based on some work that I did with Heather Tanina, who is a citizen of the Navajo Nation. And so Professor Miller's done a fantastic job of laying out the case and why it's so profound, building on this history. I want to talk to you a little bit about the environmental implications of the decision. And if we have some time, maybe also talk a little bit about criminal jurisdictional implications as well. But let's start first to talk about the environmental regulatory impacts of the court's decision. So what this decision does with a caveat, and I'll get to the caveat. So before a subsequent event happened where the state of Oklahoma asked for permission to continue regulating in Indian country, is have the effect of putting this land into the traditional regulatory scheme of environmental law, which is applicable in Indian country. And I want to tell you what that is, and then I'll tell you what happened after the decision. So in Indian country, when we're talking about environmental regulation, there is this general scheme that is applicable, at least in the lower 48. When you're looking at Alaska and you're looking at Hawaii, things are different, but in the lower 48, we do have this general scheme. So in general, tribes' environmental regulatory authority is strongest over tribal members on tribal lands. That's when the tribe has its strongest interest. Where things will generally get complicated is when you have non-Indians on non-Indian land. And of course, that's very much relevant in the environmental context because you will have non-Indian and non-Indian entities who come into Indian country and pollute, right? Because they want to do natural resource development or want to do some sort of development that leads to pollution. And so the rub really comes when you have these non-Indians on non-Indian land that are polluting. And that's all relevant. There's a lot of non-Indian land in Indian country because, as Professor Miller explained, that goes back to that history of allotment. And because most Indian country was allotted at some point historically, we now have plots of land throughout Indian country that can have different land status. So some land is held, as he mentioned, in tribal trust status by the tribe. Some land is held by individual Indians in trust status. Some land is owned by tribes as a private landowner. Some is owned by individual Indians as a private landowners, and some is owned by non-Indians as landowners. And so this just complicates the regulatory scheme. And so oftentimes when you have non-Indians coming into Indian country, they're coming into territory that is non-Indian owned. And so this brings us to this case of Montana from 1981, where the US Supreme Court looked at this issue of whether tribes can regulate non-Indians who are engaged in activities on land within the reservation. So it's within the reservation's borders, but is technically owned by non-Indians. And specifically what was happening in that Montana case is the Crow Nation wanted to regulate non-Indians who were coming in to engage in fishing activities. And if you've had a chance to go to the Crow Nation, you know that they have blue ribbon trout streams running through the reservation, and it's a destination for people who like to fish around the country. And so they had a lot of interest in regulating fishing within the reservation. And so they were attempting to regulate these non-Indians on non-Indian land within the reservation. And so what the court said in response to that is that in general, tribes have been implicitly divested of their civil regulatory authority over non-Indians on non-Indian land. And that was an extension of a decision, the Oliphant decision from 1978, where where the Supreme Court for the first time found this idea of implicit divestiture, that as Professor Miller said, typically up until that point, we needed to find or have a congressional finding that something had been explicitly divested before you could find that tribes had been divested of that authority in recognition of tribal sovereignty. But in 1978, the court looked at this issue of whether tribes had criminal regulatory authority or criminal jurisdiction, over non-Indians, and found that tribes had historically been implicitly divested of that authority. And then in 1981, in the Montana case, the US Supreme Court expanded that into the civil regulatory realm and said that the presumption is that tribes did not have civil regulatory authority over non-Indians on non-Indian land. But important for environmental purposes, the court gave us two exceptions to that. So the first is that if you agree, if you consent to the jurisdiction of the tribe, then the tribe can have civil regulatory authority over you. And that's really important. Just as an aside, a lot of tribes in the environmental context are taking advantage of that. So for example, the Navajo Nation, in some contexts, in order for you to come on as a non-Indian into the nation's territory, you will have to get a permit. And as part of that permitting process, the nation will require you to give consent to their civil environmental jurisdiction. So just as an aside, that first consensual prong can be really helpful in kind of forward looking and thinking about how the tribe can express its jurisdiction over the tribe. But in instances, over the non-Indian, but in instances where you don't have that consent, there's the second Montana exception, which is oftentimes referred to as the direct effects exception. And that exception holds that if the actions of the non-Indian have a direct threat to the health, safety, welfare of the tribe, then the tribe has the ability to regulate the actions of that non-Indian. And that was in subsequent Supreme Court precedent, the court went on to explain that that means that the actions of the non-Indian are having an impact on the ability of the tribe to govern itself. So kind of this connection between tribal sovereignty and the action of the non-Indians. Well, when we're talking about environment and environmental pollution, absolutely. There have been cases where tribes have made the argument that non-Indian pollution has substantial impacts and direct effects on the tribe's ability to both govern itself and certainly the health and safety of the tribe. So we have seen tribes take advantage of that second Montana exception in their environmental regulatory authority. But I want to let you know, for those of you who go to work in Indian country, think about that first exception and think about how you can incorporate that consensual agreement into your work with non-Indians, because that puts you into an even stronger kind of bucket in terms of being able to express the tribe's ability to regulate non-Indians on non-Indian land. And then also, in addition to this layer specific to tribes that we talked about, the Supreme Court has held that the federal environmental framework, so the Clean Water Act, the Clean Air Act, the Safe Drinking Water Act, NEPA, these are all statutes of general applicability. And so therefore they apply to tribes as well. So you've got this Montana structure, you've got tribal sovereignty over tribal members on tribal land, and then you also have the application of the federal environmental framework in Indian country. Although hopefully you've had a chance to learn and know that many of our major environmental statutes, such as the Clean Water Act and the Clean Air Act and the Safe Drinking Water Act, all have these tribes as states provisions. So the tribes have the ability, if they get regulatory authority from the EPA, to regulate just as a state would. So hopefully you've learned about the cooperative federalism mechanisms of many of those statutes where the federal government established the minimums and then the states decide how to implement them. Tribes can do that too if they get approval under this TIS provision. So that's the general environmental statutory framework. And when the court reached its decision in McGirt, it put this land into that framework for about a week. So approximately a week after the Supreme Court's decision, the governor of Oklahoma, I believe it's Governor Stitt, petitioned, and remember this is under the Trump administration, petitioned the EPA to take advantage of this midnight rider. So there's this famous midnight rider that is specific to Oklahoma, which says that the governor of Oklahoma can petition the EPA to allow Oklahoma to continue to have regulatory authority in Indian country. No other state has this. So in general, what happens when you have Indian country is the EPA has regulatory authority until and unless the tribes ask for permission under TAS. And the states, numerous states have challenged this. Wisconsin has challenged this. New Mexico has challenged this. Washington has challenged this. And the court has consistently said that no, states do not have jurisdiction. It's the EPA unless, again, one of these TAS provisions are in place, except for Oklahoma because of this midnight rider. And there was disagreement within EPA as to whether or not the language of the rider required mandatory return of jurisdiction to the state if Oklahoma makes that request, or if there's more of a permissive allowance for the EPA to determine whether or not state regulatory authority is appropriate. And so there's been a lot of discussion about this as to whether it's a mandatory return to state regulatory authority if the state makes the request, or if this gives EPA some flexibility to look at whether or not the state regulation is appropriate. However, that type of analysis didn't happen under the Trump administration, and we simply got a very short, a letter with not much analysis, much quoting to the midnight rider and to the applicable language, but not a lot of analysis as to whether the EPA had any sort of discretionary role. And so the EPA under the Trump administration did give the state back environmental regulatory authority. Approximately, I think the EPA sent that letter in September back to Oklahoma. So since that time, the environmental regulatory authority has shifted back to Oklahoma. And there's been much discussion about that, again, kind of the discretionary nature of whether the EPA was mandated to give that authority back to Oklahoma, or if EPA had more discretion. It'd also be interesting to see if the Biden administration takes this up and looks at it. But for now, there was approximately a couple months where we had this special environmental regulatory scheme that applies generally in Indian country that was applicable to the territory impacted by the McGirt decision. But then subsequently it went back into state jurisdictional authority. So this also raises issues about environmental justice. And Professor Harmon Walker mentioned that many of you are very much engaged in environmental justice, and which is fantastic, and I'm glad that you are. And so just in general, environmental justice, of course, is talking about anytime you have a disparate impact of an environmental negative externality on an environmental justice community. So those are usually your lower socioeconomic communities or your vulnerable minority communities. But what environmental justice looks like differs across the country. So what environmental justice looks like in Washington, D.C. So for example, when I lived and worked in D.C., we were doing a lot of work around the Potomac River and how communities have been impacted by pollution in the river. But in Indian country, that oftentimes looks a little bit different. And it looks different for a couple of reasons. So first is because even though tribes can be environmental justice communities, how we engage with tribal communities is necessarily different by virtue of their tribal sovereignty and by virtue of the federal trust relationship. So tribal sovereignty persists. President Biden has already acknowledged that. I think President Biden came out with a statement, I want to say it was January 26th, that was pretty quick, after his inauguration, acknowledging tribal sovereignty and acknowledging that the federal government needed to work cooperatively with tribes. So we've had an acknowledgement of tribal sovereignty by federal presidents, and then also the Supreme Court and Congress continue to acknowledge tribal sovereignty. Also, the federal government has this special trust responsibility. We could spend an entire class talking about it, but the general idea between the trust responsibility is that because the federal government has taken on this duty and has taken so many rights from the tribes, such as the ability, if you study Johnson v. McIntosh, of the fee simple land ownership, that in exchange for everything that the federal government has taken from tribes and everything that the federal government benefits related to tribes, that the federal government has this duty to act in the best interest of tribes. And so those two things necessarily inform the way that environmental justice is developed in Indian country. So tribes can be environmental justice communities, but environmental justice looks a little bit different in Indian country. So, and also anytime we're talking about environmental justice, we're talking about different types of justice. We're of course talking about procedural justice. So environmental justice communities having access to adequate procedural. Distributive justice, meaning that either the negative externalities or the benefits are being equally distributed. And restorative justice, this idea that a community has the ability to work collaboratively to overcome the negative externalities that might be impacting that community. And so for a moment, again, the tribes had this ability to engage in many of these forms of procedural justice. Because although certainly I think tribes would argue that the environmental regulatory scheme that's applicable to Indian country is not ideal because the federal government plays this role in Indian country, it's certainly better than state regulation, especially in Oklahoma, where, as Professor Miller did a great job of kind of explaining the historic antagonism between the state and the tribes. There's a lot of reasons why the tribes would prefer this federal environmental regulatory scheme over the state environmental scheme for all those historical reasons. It was only, the tribes only had access to these different types of justice for a couple of months before it switched back into the state environmental regulatory scheme. So, you know, there's this brief flash of a lot of excitement in terms of environmental justice and how tribes would be able to reclaim these different areas of justice, like procedural justice and distributive justice and restorative justice. But then when that shift back happened, back to state regulation, a lot of that shut down. And so there continues to be a lot of concern about whether or not environmental justice is actually happening in Indian country in Oklahoma. So again, we'll have to see if this is something that the Biden administration is going to look into and perhaps reverse course from the Trump administration, but definitely something to keep an eye on. There are two last points related to environmental law that I want to touch on before I turn it back to Professor Harmon Walker. So the first is oil and gas leasing in Indian country. And so this is just, so since the McGirt decision affirmed that this is still Indian country, as Professor Miller says, that means that the oil and gas scheme that is applicable in Indian country applies to this territory. So the federal government plays a significant role in energy development within Indian country. Federal statutes tend to be, as I mentioned before, statutes of general applicability. And so therefore the federal statutes that apply to oil and gas development are going to be applicable to this particular territory post McGirt. So that means that you have the Indian Mineral Leasing Act, the Indian Mineral Development Act, the Energy Policy Act of 2005, the Rights of Way Act, and the Long-Term Leasing Act, just to name a few. Now, under the Indian Mineral Leasing and the Indian Mineral Development Acts, the Secretary of the Interior is required to approve all oil, gas, and geothermal leases. So again, by affirming that this is Indian country, this is putting the land that's impacted by the McGirt decision into this framework. Also, leases for renewable energy projects must typically be approved under the Long-Term Leasing Act. Also, if you have transmission lines or pipelines that are included in project, then the Secretary must approve the rights of way for these projects. You're starting to see why part of the reason, a very small part of the reason of why Indian country has been so supportive of Deb Haaland as the Secretary of Interior, because the Secretary of Interior has a large role to play in Indian country. And again, this is just in the oil and gas context. Then under the Energy Policy Act of 2005, tribes have, if the tribes have a necessary agreement in place, they may approve certain agreements related to energy development. However, very few tribes have taken advantage of this. And then the federal government regulates energy services in Indian country under the Federal Power Act, the Public Utility Regulatory Practices Act, PURPA, and the National Gas Act. So the federal government will have a strong role in this oil and gas development within this territory, which is why after the McGirt decision, you saw a lot of oil and gas companies who were all of a sudden screaming, "The sky is falling." In fact, that's why Heather Tanana and I originally decided to write an article, is because we were getting so many news requests from news agencies saying, "Is the oil and gas industry correct that the sky is falling?" And our general response was, well, no, it's just putting them into this admittedly more complicated, but the scheme that generally exists within Indian country where the federal government has this authority. And then last, before I turn it over, I want to mention the rights of way, which is really important anytime you're talking about natural resource or energy development in Indian country. So certainly another area of law that's impacted by the court's decision in McGirt is the law applicable to rights of way, as rights of way are pervasive throughout Indian country. So rights of way through reservations such as railroads and state highways are trust land, but the Supreme Court has held that for purposes of tribal jurisdiction over state highways, rights of way are the equivalent of fee land. And this was the court's decision in Strait, where the court says, quote, "Forming the part of the state's highway, the right of way is open to the public and traffic on it is subject to the state's control. The tribes has consented to and received payment for the state's use of, in this case, a 6.59 mile stretch of public highway. They have retained no gatekeeping right. So long as the stretch is maintained as part of the state's highway, the tribes cannot assert a landowner's right to occupy and exclude." So the court's decision in McGirt does not change the fact that rights of way are the equivalent of fee land. However, as a result of the court's decision in McGirt, the rights of way are now located within tribal land. And so given this would now be non-Indian land within tribal territory. And so that Montana holding that we were talking about applies. And this is consistent with what the courts have done in Bighorn County Electric Cooperation versus Adams, where they found that there, the tribe was trying to regulate a rights of way running through its reservation. And so the court properly applied the Montana analysis. So a potential advantage when we're talking about rights of way, again, very much involved in energy, natural resource development in Indian country, which is uniquely related to the environment. Now those rights of way, even though they're still fee land and they're separate from the tribal trust land, the tribes potentially have an argument to regulate those lands under the Montana analysis. So Montana would apply there. So that is another change that will potentially impact rights of way following the McGirt decision. So those are just some of the kind of environmental related aspects of the McGirt decision. And I think we might have a few minutes for questions. So I'm going to turn it back over to Professor Harmon Walker.
Thank you so much, Elizabeth. That was an amazing history lesson, and just like Bob's, compressed into an incredibly short amount of time. So, so you guys, does anybody have any questions or comments that they'd like to share? And I think you could put them in the chat, but go ahead and raise your hand if you want to say something. Aha, Professor Miller.
Well, I'd like to add something. So while I'm calling this a bombshell, and Dean Kronk agrees this is a big deal case, Oklahoma is really only in the same position of any other state that has a lot of Indian nations inside it. I live in Arizona. Probably none of you know this. There are 22 federally recognized tribes here, and they own 27% of the land inside Arizona. So the things that Elizabeth was talking about on the environmental factor, criminal jurisdiction, civil jurisdiction, regulatory jurisdiction, adjudicatory jurisdiction, Arizona and the Indian nations here deal with that all the time. So what I think I'm emphasizing and what the bombshell is what of a societal and governmental change this is going to cause in Oklahoma, but it is no different than every other state and that has lots of Indian nations deals with.
Okay, thanks for that clarification. Eden, it looks like you had your hand up, so go ahead and.
Hi, can you hear me?
Yes.
Perfect. Okay, thank you so much. I missed the earlier part of the presentation, so I apologize if you've already talked about this, but I'm kind of wondering how the framework that you've been talking about, Dean Kronk, interacts with things like the designation of monuments. I'm thinking specifically of like Bears Ears, and if this is going to change at all the way, like the role of tribal nations in those designations? I know that it's different with Oklahoma because that land is has a different designation now, but I just wonder going forward if you think that's going to change at all.
So just to clarify, so Bears Ears is not part of Indian country. So when I use the term Indian country, I'm using it in its legal definition, which includes reservations, allotments, which Professor Miller talked about, and then dependent Indian communities, which are communities that where the federal government has set aside the land and maintains some sort of management role in those communities, which again, really interesting historical background that we could go into, but I won't. So that's the specific territory. So a national monument or a national park has a different legal status than an allotment or a reservation or a dependent Indian community under Indian country definition. So everything I talked about is the regulatory scheme that's applicable in Indian country. So because Bears Ears is a national monument, it has the regulatory structure that is applicable to federal lands, which means that the federal government is going to be the one who's going to have a lot of regulatory authority. So your major federal environmental statutes are going to apply there, but you're not going to have the tribe as regulating in the same way that a tribe does in Indian country, with the exception that Bears Ears is an excellent example that I think we can really learn from, of how the federal government actually did a fairly good job under the Obama administration, not the Trump administration, but under the Obama administration, of allowing for tribes to have real tribal consultation and engagement over the creation of that Bears Ears project. So that the process that was put in place by the Obama administration, I would say, is a great example of what tribal federal consultation can and should look like.
I very little to add on the national monument discussion. I know very little about it, but Eden, your question raises the issue of this entire area, 3.25 million acres, and now these other tribes. I believe that I've seen numbers thrown around. It's either 11 to 19 million acres of eastern Oklahoma is now Indian country. And so I can give you two examples of the implication of federal laws. Now, as Dean Kronk says, this is all Indian country. You have the Native American Graves Protection and Repatriation Act. Congress passed in 1990. This was clearly human rights legislation to treat Indian human remains the same as everyone else's human remains have always been treated. That act applies on federal and tribal lands. So now these 11 to 19 million acres of eastern Oklahoma, NAGPRA applies, where it barely applied before when it was considered state jurisdiction. You also have the Archaeological Resource Protection Act of 1979, which also applies in Indian country and on federal lands. So the reach of that federal statute and the rights tribes are given under both the statutes I just mentioned are now exponentially larger in Oklahoma than we thought they were on July the 8th.
Thank you.
Any other questions or observations? I see some professors in the audience.
Well, Elizabeth, thank you for all your comments. I'm writing them down so I can put them in my book. Thank you.
Yeah, I'm glad you're writing the book. That's fantastic.
Hey, Ann Powers, now that I mentioned professors.
Thank you very much. Wonderful presentation. I came in a little late also, and it wasn't clear to me whether McGirt now, it has been applied to the other nations. I'm from Durant, Oklahoma. I'm not Native American, but my family is from Durant, Oklahoma, home of the Choctaw Nation. And so I'm curious as to whether the same Oklahoma will treat that nation the same as it has the your nation.
My co-author is an Oklahoma Choctaw citizen. Yes, Oklahoma state courts have now recognized all four of the other enormous, what are called the 5 civilized tribes. And just yesterday, Professor Powers, an Oklahoma state court held that the reservation of the Ottawa tribe with a small reservation still exists. So if you missed my part, I mean, I am Eastern Shawnee. My tribe's in the very northeast corner of Oklahoma near Miami. And I bet our 14,000 acre reservation will still be, is still in existence And we'll just see when that case comes forward through the Oklahoma court system.
Very good, very good, very interesting.
I have a question for the speakers and anybody else in the audience who has any knowledge of this. Why Neil Gorsuch? What is it about Neil Gorsuch that made him blaze this trail? Anybody have any ideas?
He's from Colorado and Utah. He's one of ours.
Oh, okay.
Yeah, he came to swear in our first year class, and I was like, "You're our justice." He was virtual. Like, "You're our justice." You know, he's from Colorado originally. He served on the 10th Circuit for a long time. I claim him as Utah because he spent so much time dealing with the Ute cases, where the state of Utah just kept on trying to take jurisdiction from the Ute tribes. And he just kept swatting them down. Like, if you read those cases, you'll see a lot of what he wrote about in the McGirt decision, that great language that Professor Miller quoted. You see not quite as strong of a sentence. I agree. I love that first sentence too. But a lot of that kind of like the treaties are just clear. The treaties are just clear, you know, kind of over and over again. And so I think that experience that he has, and his family has deep roots. You know, his family here has a shop just in Park City. So he's got deep roots, both personally and kind of his family and professionally in the West. And I think that really matters. That really matters. You know, that's one of the critiques of the current Supreme Court, is that we don't have Westerners on the court. And he's really, I think, the only Westerner right now. And these are issues where it's really important to have that Western perspective.
Let me give you just a couple facts, Lynn. Indian country was pretty happy with his nomination. The National Congress of American Indians didn't vet him personally, but checked out his work as a 10th Circuit judge. And what the dean just said was delighted someone from the West. And I believe when he was on the 10th Circuit, he wrote 10 different Indian decisions, half of which the tribes won. I used to teach a case about radiation or uranium mining that the Navajo Nation did not win, that Gorsuch wrote. But since he's been on the court, there's been an unbelievable change in the vote, Lynn. Tribes were losing under the Roberts Court, and under the Rehnquist Court, tribes lost 80% of their cases from 1986 until Rehnquist passed in 2005. Under the first 10 years of the Roberts Court, we won one of, I believe, 10 cases. Since Gorsuch came on the court in April of 2017, he has voted in 6 Indian law cases. We've won 3 of them. And his vote was the deciding factor in all 3. They were all 5-4 decisions. So he has been everything Indian country had hoped for. We just don't know what Amy Coney Barrett? I always get her name wrong. Amy Coney Barrett. You know, her taking the place of Justice Ginsburg, we may be tipping back the other way. But Indian country is used to losing all their Supreme Court cases. Every tribal attorney has told every tribal leader, do not take a case to the Supreme Court since Rehnquist became the chief. Don't forget Scalia joined the court that year too. So the Supreme Court has been very unfriendly to Indian country since 1986.
Yeah, I would just add, you know, people make presumptions about me because I'm a woman of color, but I would always kind of shock people when I would say that I much prefer Gorsuch for all the reasons Professor Miller said over Ruth Bader Ginsburg, because he's just much better on Indian issues and tribal sovereignty than she was. She was always kind of a unknown variable because I don't think she really understood tribal sovereignty. And that was always kind of shocking to people when I would make comments along those lines.
Well, thank you, everybody. We went a little over, but I think it was worth it. And we'd love to have you back for round 2 at some point.